All right, let's go on the record. The matter of State of Arizona versus Lane Jeffrey Myers, CR 2025-1060. The time set for evidentiary hearing on jail calls, parties' appearances. We'll start with the state.
Rachel Stiles for the state.
Lane Myers for myself.
All right, and Mr. Parvin is your not standby. I keep advisory counsel. Sorry. So I want to address a few things for here from the parties. So I thought the hearing on Friday did not go particularly well with respect to the way the courtroom was supposed to operate. So, Mr. Myers, I thought that you were disruptive during the course of that hearing, and I want to address that for today's hearing. I don't want today's hearing to proceed as Friday's hearing did. First of all, your right of self-representation can be withdrawn. In Arizona, criminal defendants have a constitutional right to self-representation, but the right to self-representation is not absolute and may be terminated when a defendant deliberately engages in serious or obstructionist misconduct. Serious and obstructionist misconduct includes serious violation of court orders and rules when the conduct signifies that continued self-representation would undermine the court's authority and the ability to conduct the proceedings in an efficient and orderly manner. Withdrawing your right of self-representation, I do have to give you clear, unambiguous, and timely warnings, which I'll do today. Conduct that can cause a defendant to lose the right of self-representation includes displaying utter and complete disrespect for the court, verbal outbursts, the tenor of those outbursts, consistent disregard of the trial judge's warnings, and wild antics in court. So some of the things that we're not going to do today is talking over me or over the prosecutor, swearing, calling the prosecutor or victim's names, continuing to speak when I have asked you to stop, threatening behavior, including trying to stare me down, encouraging others to harass the prosecutor, the victim, or court staff, being disruptive, talking faster than the court reporter can take down your comments. And if I find that you've done that, I will advise you to stop. And if you persist, I'll find that you've waived your right to self-representation, and then your lawyer will take over, and you will not speak at that point. If you continue to be disruptive, I'm going to order you held in a different courtroom, and we set up a Teams link so you can listen to what goes on in the courtroom. At the same time, Mr. Myers, you do have the right of self-representation, and I don't want to withdraw that right to you, but it's up to you to act in a professional manner and not disrupt the proceedings. So with that, I'm going to start with the state, because it was the state's request for this hearing as to Mr. Myers' phone calls with those who record those phone calls and then broadcast them, and the concern was that they could be used to harass the victim. So, Ms. Stiles, where are we on that?
Your Honor, I think Mr. Myers had something that to address the court with. He had his hand up.
All right,
So
Mr. Myers, what do you want to tell me?
Well, thank you, Rachel. I wanted to, when you're talking about the decorum and all that, I wanted to apologize for the last time and say I understand. I want to make it clear to you that I understand what you're saying, and I understand my responsibilities as both the defendant and the attorney, especially since I'm about to become my own attorney and all this. And so the thing is that it's all new to me, so I don't claim to have a bunch of courtroom decorum experience. I do think I know somewhat about the law, but that doesn't mean that I can act a certain way.
Okay.
I want to say I'm sorry, and I do realize that it's a tough situation being up there. To me, court is supposed to be adversarial, but not with the judge. Not, and when it's my turn to talk, that's when I can be adverse to their position, to my position, not. Right. And it wasn't my best day that day.
All right.
I wanted to know that right off the bat.
And I know you're under a lot of stress. Everyone who comes to the courthouse is under stress. You're in custody. You think that you are being wrongly accused, and I understand that. In part, we have to have decorum in the courtroom so that everyone can be heard, and so one person gets to speak and everyone else listens while that person's speaking. So I appreciate that. All right, Ms. Stiles, what's the state's? How do you want to proceed today, or what is your? What do you want to address?
Your Honor, so I was prepared to put up exhibits to show the live streams and then to play jail calls, also referencing that he, first of all, knew that he was being live streamed and that he was using that as a means to cause potential harassment then to the victim and then as well as the court. My understanding from Mr. Myers, though, is that he is agreeing that he will not be live streaming from the jail, meaning he's not going to call somebody else so that they can then live stream him on YouTube, and that he's agreeing to that during the pendency of this case. Is that correct?
All right. So the parties are going to enter a stipulation that the defendant will not live stream any calls from the jail? Yeah, go ahead. Yes.
Yeah, and thank you, Rachel. Yes, because after that hearing, during that hearing, it was, the first I had heard about it was during the hearing. Right?
Uh-huh.
So then, as soon as she brought it up, I saw the concern she had, right? And so to me,
Turn the mic. No,
pull it down.
they're not hearing.
Sorry.
You got to turn that.
So I got to speak into this.
It helps.
You got to. It bends.
It bends.
It can bend.
There we go.
Thank you.
Have to be that close, but it just has to be pointed to you.
Thank you. Your Honor, when I was the message I was trying to get through to Rachel as well as you is that, okay, we're all adults, right? Clearly Rachel has a position that what I was doing was interfering with some type of the process, right? And you seemed concerned enough to want to have this hearing and stuff like that. And it's my thing is like, well, I'm an adult, right? I'm a grown man. Well, if you're telling, if Rachel's sitting over there saying, we have this concern and we need to bring it to the court, well, that's easy. I stopped doing it then, and self-regulation. I mean, I have a duty to this court just like as my own attorney, just like, anybody else is a defendant and an attorney, that I have to behave as the defendant. And then I also have to act professional as the attorney. And so giving myself legal advice, the attorney me giving the defendant me legal advice, well, obviously, let's remove any tension between myself, the prosecution, the victims, and all that kind of thing. Well, that's easy. You don't want me to go on YouTube. You don't want me to go, you don't want me to live stream on YouTube. You don't want to hear my calls from jail being played on YouTube. Well, then that's simple. I won't do that. And, and it's a simple matter of I take responsibility. It's one of those things where you're kind of assuming, well, it might be a gray area, it might not. And now here we're at a hearing and last week, and she's saying, I got a problem with this. So I'm saying, well, if you got a problem with it, I'll stop. And I obviously she can attest to this too, or whatever the word is, testify to this, that I haven't done it since, right? I mean, I haven't.
That's correct.
Okay.
And I made sure that I'm telling people when I'm on the phone, do not contact the victim in any way, shape, or form. Reference the victim. Bring attention to the victim. Mostly I'm trying to say that, like, I'll be straight with you. I was being critical of you, right? And so that's like one of the things. And to me, it's like, well, if it's simple as protecting the victim, that's different than the court, right? It's two separate things here. Like, right. The victim is a higher priority than necessarily the judge hearing that I didn't like his ruling on the slap or something, right? But that doesn't mean that I can't agree to that, because if she's going to play a conversation where I'm making condescending remarks about you, that's going to open it up for you to have not that you can't remain impartial, but I think the best for everything is Lane, just stay off YouTube.
Okay. Well, with that, I don't know that we need to address that. If a problem comes up in the future, we can address that in the future. Was there anything else? We're going to talk about the schedule a little bit, but anything else we needed to address today?
Your Honor, just that this came up in one of the videos is by the YouTube person that he's been in contact with. The disclosure that we provided was then somehow provided to that person who then had shown it all on his YouTube channel. And under Rule 15.4 of the Arizona Rules of Criminal Procedure, subsection D.
D as in David?
Yes. Disclosure provided in this case cannot be disclosed publicly. So we have an obligation to provide the disclosure to Mr. Myers, and he needs to have the disclosure, but that disclosure then cannot be given publicly. And this was back on March 18th that happened. And so I just want to make sure that that's clear to Mr. Myers so that he understands it and is aware of that rule so that we don't have that issue come up.
different police reports and certain disclosure, not all disclosure, but certain things that are a matter of public record, anybody could go get a copy of that police report from the police department and pass it out. Now, I understand the concerns of me giving it out, and again, it's the same thing. I'm not in jail, so it's going to be kind of hard to do that. Or, I mean, excuse me, I'm in jail now. I wasn't then. And, you know, the press does have the right to the public records, but also we have to find a balancing act between, you know, disclosing things that influence the public and just disclosing matters of public record. And again, I'm not fighting to this isn't the hill I want to die on, for lack of a better term, about, I just want the disclosure. And I feel like specifically the reason, and I'd like to address this with Rachel, because maybe something needs to be done, but the police report says that I was their ex, right? And that's why I released it, because it literally says in there that Shannon Walker's my ex, right? And that's a police report signed under the penalty of perjury, okay? And that's a public record. And I wanted to, and I feel that's the very spirit of Rule 3.6 of trial publicity, is to correct misstatements or miss things. And if I'm out here charged with domestic violence and charges related to having a romantic or sexual relationship with this woman and I never had, I felt in that moment, release this police report where it literally says, my ex, Shannon Walker. She's not my ex. And I felt for the public to know that I'm being charged if she's my ex, this is why the police report says that, not because it's true. And so, like, I agree with Rachel. It's not, we don't need to litigate the case in the YouTube channel. You know what I mean? So, like, if Rachel wants a strict interpretation of 15.4, that's fine. But also, technically, it needed to be redacted, and you can share some of it. And there was no court order saying I couldn't at the time, right? Now, I realize that the court can impose those conditions. At the moment, there wasn't, right? But so that defaults back to Rule 15.4 as a default, right? They release it, they say 15.4 default, right? They release it, they say 15.4, you can't release it. That balancing act of, well, how much of this do I need to release to make sure that the public knows that's what's really going on? And how much of this are you just doing to just do it, to just, you know what I mean, put everything out there? And so that's where, again, I'm an amateur when it, you know what I mean, this is my first, so I'm not against, you know, working with Rach saying, oh, because obviously I'm in jail, I won't be putting nothing out from jail. I just want to make sure that she's referring to, like, publicly on YouTube. There should be no reason I shouldn't be able to, like, talk about the police report with my wife or my friend on the phone, or like an attorney consultation type thing. I believe if Rachel, correct me if I'm wrong, you're more worried about, like, public, like out there on the public, like, domain, right? Like out into YouTube type public domain.
Yes, the rule specifies about putting out into the public. And so even though that these are police reports, I don't consider them public records. I don't think the law considers them public records. If they were to get them from the police department, there may be more redactions that would come if they did a public records request than what happens when I give them to the defense. And then the other issue is
Let me ask this. When you disclose them, are they completely unredacted?
No, so we have to redact the victim information and anything that's considered egregious. So those are the things by law. So we don't have body-worn cameras in this case, but if we had a body-worn camera and they had their computer displayed, that has to be redacted. And then victim information always has to be redacted out. Everything else is in there. So the concern wasn't just that one police report he's referencing. It's that there were emails that have been sent, and they have been both supportive and, you know, against the victim in this case. And their information's all being put out in the public domain, which is also then leading, you know, that the public could then contact those people or contact witnesses, contact people involved in the case and try to intimidate people in the process. And what was happening on that channel is people that were in support of Mr. Myers, they were redacting their information and then leaving the other people's information, which is suggestive that it's being used. And I'm not saying Mr. Myers did this, and maybe the person he sent it to is then putting it out there where it could lead to intimidation of witnesses. And we just want to make sure that we keep the process, you know, clear of intrusions from outside people who don't know the situation and are trying to influence the process. And then I just want to address his issue with the one police report that had the error in it. That law enforcement officer no longer works for the agency, which is why there hasn't been anything filed to change that. Okay. So that's the information the detective gave me about it.
Mr. Myers, a couple things. Police reports can be accessed as public records. What I hear from the state, though, is that when they do it, they may make more redactions than are redacted for disclosure.
Less.
Okay. Well, I can't, I don't have it in front of me to know exactly, but I guess what I'm saying is that 15.4D does prohibit you as a litigant for when you get information and disclosure, you cannot publish it to the public. That's different than if someone else goes to get a public record, what they can do with it. That makes sense? In other words, when you get it as disclosure, this rule applies, even if someone else could go down to, what is it, 40 South Zone, 20 South Zone?
600 or something. I know what you're saying.
And get that themselves. So, I think we're just talking about, going forward, just to admonish, that 15.4D does, preclude you from disclosing, the information you receive in this case to the public. That make sense?
And then, Your Honor, on specifically the grand jury transcript, the grand jury transcript is itself a protected document. And so again, Mr. Myers may not have been aware of the statute, is that he can't just be reading and talking about the results of that. And so I want to caution that just because, he's going to get another grand jury transcript, I just want to make sure he knows that that's actually an offense.
Not aware of that.
Okay. And that's one of those things, you wouldn't have gotten that, but for your status as a litigant, that's why you got it. But there are statutes that provide, that those can't be publicly disclosed. So, the inability to produce, information to the public would include the grand jury transcripts. Yes.
I just wanted to clarify something for the record, and I'm not disagreeing with Rachel, but the police reports, when you go get them from the police department, they actually are not redacted. The victim's information would have been shown, and on top of that, we went out of our way to redact every single one of those emails. I want the record to reflect. If you put that video up right now, I made sure, I said, do not release this without redacting it. So the channel she's talking about spent hours redacting all those emails. They might have shown like the first part of a couple, but not there was no way for anybody to watch that video and email anybody off that video with the complete email address. But I'm not sitting here trying to nitpick with Rachel either. I get her point too.
Okay. All right. So that we've addressed the 15.4D issue. Anything else we need to, and again, I'll talk about the schedule here in a moment. Anything else we need to discuss?
Your Honor, are you able to do his arraignment today? I believe the documents should be now available to the court so that we could do the arraignment.
Please.
I looked it up, and only the first page of the indictment was available. Let's see if I can get this changed at all. And I don't, what happens with an indictment is that it's a printed document that's signed by the grand jury foreman and the prosecutor, and then that's uploaded. So it's not electronically filed. So let me look again.
Yeah, I see it's only an agave showing the first page.
Yeah, and that's what I'm saying. Somehow it didn't all get scanned in when it was.
I don't know if there's a way for the court to get it. I just think it would be better for everybody's time if
Agave is the only access I have.
Okay.
So.
Friday.
Yeah, so it's Friday. Well, why don't we, again, I don't want to go forward to the indictment, arraign on the indictment, because I'm not confident that there's only 3 counts, for example, and I just got to have the whole document. And so, again, Mr. Myers, what I got was page 1. That's what's on.
I haven't got anything.
Yeah, you don't. This is on Agave, but it doesn't have the whole thing, because there's obviously got to be a signature page as well, which I got to make sure that it's been signed properly before I can arraign. So.
Can you clarify something about because again, first grand jury transcript thing.
Right.
There's a rule that says you can't talk about, or like that can't be like released to the public. Is that what the contention is, Rachel?
It's a statute, is it not?
It's a statute, and revealing it's a class 1 misdemeanor. So
okay.
That's why I just want to make sure that.
Like ever revealing
I think you have to get court order to.
Yeah, it has to be under court order that can be released. Okay. That's why I just want to make sure that Mr. Myers was, put on notice of that so he knows.
I didn't even know that. So unless there's a court order, it's private.
Correct.
It's considered like sealed or something type thing?
Yes, exactly. All right, so I'm going to leave it to one of the hearing officers to do the arraignment on Friday. And then in this case,
Because we'd also like to set the next, like, representation here at the same time if possible.
Yeah, so in our case, the first case, I'll say, we have a case management conference on the 15th. You could file a motion, Ms. Stiles, to accelerate the case management conference in the other case. If you could do that, and then we could get them both on the 15th, or set a status conference, whatever you want to. Or I could set a status, well, can I set a status conference, I guess, before he's arraigned?
So at the arraignment hearing, we can just make sure it gets set on the 15th
Okay.
along with the other case.
Can you make a note, whoever's covering arraignments, to do that?
I'll be there.
Oh, you'll be there, okay, all right.
So I'll make sure that they get
Okay.
put together.
All right, so, Mr. Myers, what's going to happen is, the case management conference is, and at that, we'll talk about the status of discovery, and I intend to also do the pretrial conference so we can set that trial date. At the arraignment on Friday, Ms. Stiles will be there, and she'll ask the judge to set a case management conference and pretrial conference on April 15th in the new case. So when we come here on April 15th, both cases will be here. And when we set hearings, they always have to give April 15th is next.
Friday or what?
Let's do that on the 15th as well.
Okay.
Yeah.
And if he files anything, now for the one case number,
The current?
the current case number, and then second one, then he can just do a motion to also put it under the other case number. That would be fine.
Yeah. And I'll, let's just do that. And we'll make sure, Mr. Myers, that if you're filing something that would address both cases, that I'll make sure that it covers both cases.
They won't.
I intend to, I'll just tell you, as of right now, unless something happens between now and the 15th, I would intend to allow you to represent yourself, but we have to have that formal hearing. But you haven't been arraigned on it, so
It's kind of like a procedural.
it's a procedural thing. And there's what's called regular order, that we have to follow these rules. And I know that it's like, I just want to get to this point, but we just have to do it, okay?
May I say something, Your Honor?
Yes.
On Friday, since it's just an arraignment, a matter of semantics, usually that's just covered by the standing attorney. I don't know if the court needs me specifically for an arraignment just to say we're ready for the next court date.
Any reason why
Usually a standing and arraignment attorney, okay.
Yeah, so there's always a defense attorney assigned to those. So that's
Yeah.
up to them of whether they want that person to stand in. The release conditions are already set because of the no bond hearing, so
Right.
it's
Okay.
only the
See,
arraignment, but
Mr.
that's
Myers,
up to them.
And
Mr. Myers, you're
I don't mind being there, but it's double coverage.
What's the
They
date?
might-
Friday date.
Friday,
The date.
the 4th. That's the arraignment. So, Mr. Myers, you have no objection if just the covering defense
No,
counsel?
because it's just procedural, right? Arraignment.
Correct.
And then we can get to the Ferretta and all that.
Correct,
Now,
on
they
the
did say, he asked me to say something about a settlement conference. That's something that he just whispered in my ear.
So, Your Honor, I'm not sure where Mr. Myers is, if he's interested in a plea agreement or not. It seems like that's gone back and forth of whether he is or isn't. I would suggest a settlement conference, so we can just schedule that, at a time that works, and we'll just make sure that that Mr. Myers is transported for that. So that's up to him. But I don't want to have a settlement conference if he isn't actually interested in discussing.
Would you be
a
interested
possible
in it?
Yeah, I mean, I would sign a plea bargain today, but I was told yesterday that Rachel doesn't want to do that for a few weeks.
Okay, remember we talked about the separation of powers?
Why not?
And one, just hold on. One of the things is, only the state can decide whether to offer a plea or not. I'm not involved in that. You can go before a different judge, not me, to talk about a plea. Again, that's up to you all. At the same time, remember, you want this set for trial as quickly as possible, and I think it should be set for trial as quickly as possible. That sometimes is inconsistent with plea negotiations, which can go back and forth, and we have a victim in this case, so they have to reach out to the victim. But I think she's going to set a settlement conference, and she can make a plea offer if the state wants to.
Is that like an open court?
It's a written offer, and then they give it to you as a document.
Okay. And it's not the trial judge?
The settlement conference is before another judge. It's off the record, though.
Okay.
It's not live streamed or.
Perfect.
It's
kind of like a civil thing, too.
correct. Correct. If you take a plea, that's obviously on the record.
Oh, yeah, for sure. But I mean, the discussion itself, and it's confidential, right?
Yes.
Like, when I also have the obligation to not leave that settlement conference and talk about it, right?
Correct. Yeah, it's confidential. And the reason for that is sometimes people will speak frankly about the case and they don't want that to be used against them at trial.
So
And
there's like some kind of rule that says that what we talk about can't be used against you?
yes,
Yes.
it's
Okay.
is it 408 or 411?
Okay.
Yeah, it's in the evidence rules.
It's in the evidence rules in the chapter 400 series.
So it's kind of like civil, anything we talk about, any monetary, all that, can't talk about.
Right, right. It can't be used against you.
Thank you.
All right. So we're going to be back in court on April 15th in this case.
And Your Honor, one more. So Mr. Myers let me know. I didn't know that the jail no longer has a specific law library. It sounds like they've changed that to their tablets, but it sounds like he may not have access to that. So I'm going to talk to a lieutenant at the jail to just make sure that Mr. Myers has access to everything he needs so he can do his research.
Right.
I don't know if he has paper and pen yet. It sounds like OCAC, if he's not able to get that,
Things, if you tell me what you need.
that Mr. Parvin can work with OCAC and
You don't have any pens at all?
the public
I have nothing.
defense. So that he can work with the public defense services to make sure that he is supplied with paper and pens as needed so that he can then take care of those issues. And then they also can supply Mr. Parvin with a computer that can play everything so that he has access to make sure he's able to review all the disclosure.
Okay.
So I think that hopefully will take care of his issues with not having access to things for him to be able to represent himself.
All right.
So if there are further issues, they can just notify
So
if there's an issue so that we can make sure it gets resolved.
Mr. Myers, one reason to have advisory council is if you have issues like that, you can call Mr. Parvin and say, hey, I can't get this, this, and this, and then Mr. Parvin can work to do that. That's an important part of what advisory council does. But you have to tell him, and it sounds like we're going to get that set up.
Yeah,
If it's not,
I get some paper.
Because once you gave the official, like last week you said, there's an order now to go to the law library. Well, I put something in and they go, oh, we got rid of the law library 2 years ago.
yeah, they have to have something there.
Yeah, so I wasn't aware that they got rid of their official law library, but it sounds like they're doing it through the tablets. But I will find out and make sure that he has access. And if there's any issue that he's not getting access, I'll notify the court so the court
Yeah.
can enter whatever orders are needed.
Yeah, because that's important, obviously, that he. I don't know the exact. I don't know the exact state of the law, but obviously he has to have the ability to do legal research for his defense. And then whether that's through Mr. Parvin, through paralegal, or how they do it, I don't know that. I'm not making a ruling on that, but we need to track that down so that that's addressed.
Is the court we're going to allow handwritten motions? Is that, we're under that understanding?
You can do handwritten motions as long as I can read your handwriting. And so I'll tell you.
They don't have any other option.
Yeah, just the other thing you could do is you could give a handwritten motion and Mr. Parvin could have it typed up. I take it as that.
Very busy, and he's a one-man show.
If it's something I agree with, I don't mind it. If it's your name on it, I can type it up for you if it's something you want to write.
Yeah, I mean, I'm just telling you, it's better for
unique.
you
No,
if I
know.
can read it. Okay,
Oh,
I'm just
well,
telling.
I agree. But I mean, I can put, a heading, Superior Court, blah,
Yeah.
blah, and you're cool with it being handwritten and stuff.
Yes.
Right, okay, thank
Yeah,
you.
and
I
there's
just
ways-
need paper. I just need a way to write it now.
Right.
And I just want to clarify that I know we're on the other case, but I'm still appointed on that case until April 15th. If I decide a motion's in the best interest, I believe I can still file it at this point, unless you order me not to file
No.
motions.
I agree with that.
Yeah.
I mean, if they agree.
Yeah, that's fine.
Let's make it clear you said you want to present yourself,
You're
but
right.
I may file
In that
a
intervene,
motion
right?
in
No,
that-
right, exactly.
Yeah.
Okay.
Mr. Parvin's still the attorney of record in the newest case matter.
And that's kind of why they also said the law library is still I think what she's saying is about they're going to give me the tablet for maybe more time than the other inmates or something. Maybe that's how the law library.
Yeah,
We all got to share the tablet, and it's like we only 25 people sharing a tablet. And if I need to sit there for 2 hours and do legal research and write down a motion and all that, it's kind of like I'm not really
right.
special enough to take away the privileges of somebody else calling their family or something. And so, as long as go ahead.
I'm sorry, I didn't mean to interrupt.
Well, it's like so I feel like it sounds like Rachel's going to do her due diligence and try to figure out a way that I get like a dedicated time where it's like you get to use this right now to do the law stuff.
Yeah, I think she's going to look into this, and if it hasn't been resolved, we have to come back to court, and we'll have to have someone from the jail here to go over that. So that it's an important part of your defense. Okay, so we're going to come back on April 15th, and I think we'll have the two cases. And I don't know if that, so what that means, I'll call both cases. They're two separate cases. There may be a motion to consolidate to try it all at once.
Sure.
Either side.
Okay.
There's a rule of criminal procedure that allows for consolidation. So someone might want me to make,
Are you gonna file that?
might want to make that motion if you want to try it all at once or to trial. I'm not prejudged. I'm just saying that should be addressed.
Yeah,
So
I
if we-
do want that. If Rachel, you want to file it, we stipulate. I don't know how you want to do that. If we each need to file a motion or what, but if it's stipulation, whatever.
I can put in the motion and then put his position into it.
Okay.
Thank you.
All right. Anything else? All right. We're going to see you back on April 15th. And that's on the 9 a.m. calendar, correct?
Thank you, sir.
With that, we're adjourned to your excuse. Have a good day, everybody.
You too.
All right, everybody, in the description, you're going to see a House Rep Alexander Kolodin. There's a phone number and an email address. Reach out to this guy. He's putting forward a House bill in Arizona right now. I think it's 2043. But this guy needs to be overwhelmed with calls and emails, letting him know about the political prisoner in Pima County Jail. All right, everybody have a good day.